Question 1. When developing a solution that must address opposing needs, a shipowner disputes a salvage claim after a vessel ran aground in international waters. The salvor demands full compensation under the 1989 Salvage Convention, arguing that their services prevented major environmental harm. The shipowner, however, refuses to pay, stating that the danger was minimal and that the crew managed most of the situation. What will be the key considerations in determining the validity of the salvage claim? A. Whether the salvor provided a service that resulted in a successful salvage operation, regardless of the severity of the risk. B. Whether the salvage operation prevented an environmental disaster, making it eligible for special compensation under Article 14 of the 1989 Salvage Convention. C. Whether the shipowner consented to the salvage operation before it began. D. Whether the salvor had a contractual agreement in place with the ship before providing assistance. Answer. B. Whether the salvage operation prevented an environmental disaster, making it eligible for special compensation under Article 14 of the 1989 Salvage Convention. Explanation. The 1989 Salvage Convention recognizes both traditional salvage claims and special compensation for environmental protection. Under Article 1A, salvage is defined as any act that assists a vessel in danger. The key legal issue here is whether the salvor's actions substantially reduced environmental damage. Option A is incorrect because salvage compensation depends on more than just providing assistance. It requires proof that the salvor's efforts led to a successful outcome and mitigated risk. Option C is incorrect because prior consent from the shipowner is not required for a salvage claim. Under the no cure, no pay principle, salvors can act in emergencies. Option D is incorrect because salvage is not dependent on pre-existing contracts unless the parties agree in advance, such as in Lloyd's Open Form, LOF contract. Legal references: International Salvage Convention 1989, Articles 1A 13 and 14, the Nagasaki Spirit Case 1997, which clarified compensation rules under the Salvage Convention. Question 2. While analyzing the root causes of sequential problems in marine insurance claims, a ship suffers engine failure due to improper maintenance by the crew, causing it to drift into a restricted environmental zone. The shipowner files a claim under the Hull and Machinery (AICM) policy, arguing that the failure was an unforeseen mechanical issue. The insurer, however, rejects the claim, citing the crew's negligence. Under Admiralty law, what is the most likely outcome of this dispute? A. The insurer must cover the damage because hull insurance policies include negligence by the crew. B. The claim will be denied if the insurer proves that the shipowner failed to exercise due diligence before the voyage. C. The claim will succeed if the shipowner can prove that the crew's negligence was outside their direct control. D. The insurer will only pay if the shipowner can show that the engine failure was a result of a covered peril under the policy. Answer. B. The claim will be denied if the insurer proves that the shipowner failed to exercise due diligence before the voyage. Explanation. Under marine insurance law, particularly the Marine Insurance Act 1906 UK and Institute Hull clauses, a shipowner must exercise due diligence to ensure the vessel is seaworthy before a voyage. Option A is incorrect because while marine policies do cover crew negligence, this only applies if the shipowner took reasonable steps to ensure proper maintenance. Option C is incorrect because the shipowner is responsible for the crew's actions under the doctrine of vicarious liability in maritime law. Option D is incorrect because covered peril, e.g., storm damage, must be the primary cause of loss, but here the issue was crew negligence and lack of maintenance. Legal references: Marine Insurance Act 1906 UK, Sections 39, 41, Seaworthiness and Due Diligence. The Starsea Case 2001 clarified insurer liability in negligence-based claims. Question 3. During a major transformation where existing methods must comply with strict legal frameworks, a ship carrying hazardous cargo collides with a fishing vessel in an exclusive economic zone. The shipowner invokes the Limitation of Liability Act 1851, seeking to limit liability to the value of the vessel and pending freight. However, claimants argue that gross negligence and failure to follow COREG should remove the limitation. How will the court likely rule? A. The shipowner can limit liability unless the claimants prove intentional misconduct. B. The shipowner cannot limit liability if there is evidence of gross negligence or reckless behavior. C. The limitation will automatically be denied if the ship was carrying hazardous materials. D. D. The court will limit liability but require additional compensation for environmental damages. Answer: B. The shipowner cannot limit liability if there is evidence of gross negligence or reckless behavior. Explanation: the Limitation of Liability Act 1851 U.S. and the International Convention on Limitation of Liability for Maritime Claim (LMC 1976), as amended in 1996, allow shipowners to limit liability unless there is evidence of recklessness, gross negligence, or intentional misconduct. Option A is incorrect, because even if misconduct is not intentional, gross negligence is sufficient to break the liability limitation. Option C is incorrect, because the presence of hazardous cargo does not automatically prevent limitation, but non-compliance with safety regulations can. Option D is incorrect, because while courts may award separate environmental damages, the focus here is on whether liability can be limited at all. In the Deepwater Horizon case 2010, the U.S. courts found that BP could not limit liability due to gross negligence in safety procedures, setting an important precedent for how reckless actions void liability caps. Question 4. While investigating inconsistencies across various units in a multinational shipping company, it was discovered that certain vessels were operating under flags of convenience (FOC) to evade stricter regulatory requirements. One particular vessel, registered in a jurisdiction with lax labor laws, was involved in a collision in international waters. The injured seafarers sought compensation under the Jones Act, while the shipowner argued claims should be governed by the laws of the vessel's flag state. Considering principles of shipowners' liability and seafarers' rights, how should the court determine jurisdiction in this case? A. The court should apply the Jones Act because the injured seafarers were employed by company with U.S. ties. B. The court should defer to the flag state's jurisdiction, as ships are subject to the laws of the country in which they are registered. C. The court should apply the doctrine of forum non-conveniens and dismiss the case in favor of the flag state's courts. D. The court should deny the claim entirely because international waters do not fall under any single jurisdiction. Answer A. The court should apply the Jones Act because the injured seafarers were employed by a company with U.S. ties. Explanation: under the Jones Act, 46 U.S.C. SS 30,104, seafarers employed by U.S. affiliated companies can sue for negligence if they are injured in the course of their duties, even if the vessel operates under foreign flag. The U.S. courts have exercised jurisdiction over FOC ships when there is significant connection between the employer and the United States. Lauritsen v. Larson, 345 U.S. 571, 1953. Option B is incorrect, because while flag states generally have jurisdiction over their registered vessels, the U.S. courts can override this when there are strong ties to the United States. Option C is incorrect, because the doctrine of forum non-conveniens is discretionary and does not automatically exclude case from U.S. jurisdiction. Option D is incorrect, because international waters do not mean legal immunity. Various treaties and national laws establish jurisdiction depending on ownership and employment connections. Question 5. During a comprehensive review of a process that needs improvement in a maritime insurance dispute, a cargo owner filed a claim under a standard marine insurance policy after severe weather damaged goods in transit. The insurer, however, denied the claim, arguing that the proximate cause of the loss was an act of God, which is an excluded peril. The insured contended that the ship's crew failed to take necessary precautions to mitigate the loss. Based on principles of marine insurance law, how should the claim be resolved? A. The insurer is correct in denying the claim because force majeure events are not covered under marine insurance. B. The claim should be paid if the insured can prove that negligence by the crew contributed to the loss. C. The insurer must compensate the insured under the sue and labor clause, regardless of the cause of loss. D. The claim should be denied because weather-related losses are never covered under marine insurance. Answer: B. The claim should be paid if the insured can prove that negligence by the crew contributed to the loss. Explanation: marine insurance operates under the doctrine of proximate cause, meaning the insurer must determine whether the dominant cause of the loss was an insured peril. The Marine Insurance Act 1906 UK and equivalent U.S. laws state that if crew negligence exacerbates a loss, the insurer may be liable despite an act of God claim. Option is incorrect, because while acts of God, force majeure, are generally excluded, the crew's negligence can make the insurer liable. Option C is incorrect, because the Sue and labor cause requires the insured to mitigate damage but does not create separate obligation for payment. Option D is incorrect because weather-related losses can be covered under hull and cargo policies depending on policy terms. Question 6. In a case where multiple parties have different objectives in a ship mortgage dispute, a financial institution attempted to enforce a preferred ship mortgage under the U.S. Ship Mortgage Act. However, the vessel was already subject to several maritime liens, including claims for crew wages and salvage services. Which claim should take priority in the court's ruling? A. The financial institution's ship mortgage claim because it was registered first. B. The crew wage liens because they are considered superior under maritime law. C. The salvage lien because it directly benefited the vessel's preservation. D. The claims should be ranked equally and the proceeds split proportionally. Answer B. The crew wage liens because they are considered superior under maritime law. Explanation: under the U.S. Ship Mortgage Act, 46 U.S.C. Chapter 313, maritime liens for crew wages take precedence over ship mortgages due to their preferred status. Courts recognize the importance of compensating seafarers first, as seen in the John G. Stevens 170 U.S. 113, 1890. Option A is incorrect because the ship mortgage does not automatically outrank maritime liens. Option C is incorrect because salvage liens are high in priority but still rank below crew wages. Option D is incorrect because lien priorities are not equal if they follow a strict legal hierarchy. Question 7. When scaling up operations that experience significant legal challenges, a global shipping company decided to adopt arbitration clauses in all of its charter parties. A cargo owner, dissatisfied with damages awarded by an arbitration panel, attempted to appeal in a national court, arguing the arbitration agreement was unfair. Under international Admiralty law, what is the most likely outcome? A. The court will set aside the arbitration award if the cargo owner proves the agreement was unconscionable. B. The arbitration award will be upheld unless there was fraud or a violation of public policy. C. The court will review the arbitration decision on the merits and potentially revise the damages. D. The case will be relitigated in court, as arbitration clauses do not have full legal effect in maritime contracts. Answer B. The arbitration award will be upheld unless there was fraud or a violation of public policy. Explanation: under the New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards, 1958, courts have limited ability to overturn arbitration decisions. An award is only set aside for fraud, public policy violations, or procedural irregularities. U.S. courts follow this approach under the Federal Arbitration Act, 9 U.S.C. SS 10. Option is incorrect because unconscionability alone does not justify overturning an award. Option C is incorrect because courts do not re-evaluate the merits of arbitration decisions. Option D is incorrect because arbitration clauses are legally enforceable in maritime contracts. A. Whether the ship owner had privity or knowledge of negligence. B. Whether the damages exceed the vessel's post-incident value. C. Whether the oil spill affected multiple jurisdictions. D. Whether the vessel had limitation clause in its charter party. Answer A. Whether the ship owner had privity or knowledge of negligence. Explanation: the Limitation of Liability Act of 1851, 46 U.S.C. SS 30,505 allows ship owners to limit liability unless they have privity or knowledge of the negligent act that caused the damage in Re Hercules Carriers Inc. 768 F.1558, 11th Sir. 1985. Option B is incorrect because limitation depends on fault, not just vessel value. Option C is incorrect because jurisdiction does not impact limitation rights under this law. Option D is incorrect because limitation statutes override contractual limitation clauses. These complex, detailed questions should challenge students and provide deep insights into Admiralty law concepts. Let me know if you'd like further refinements. Question 9. While investigating inconsistencies across various units in a multinational shipping company, an environmental agency discovered that a cargo vessel had been illegally discharging ballast water in a protected marine area. The vessel's owner claimed that the discharge was accidental and should not result in penalties under international law. However, local authorities insisted that the ship violated the Ballast Water Management Convention above. The most likely legal outcome: A. The vessel owner will not face penalties if they can prove the discharge was accidental. B. The vessel owner can be held strictly liable under international environmental law. C. The vessel will be blacklisted from entering international ports, but no financial penalties will apply. D. The ship's flag state must handle the violation exclusively without intervention from the coastal state. Answer: B. The vessel owner can be held strictly liable under international environmental law. Explanation: under the International Convention for the Control and Management of Ships' Ballast Water and Sediment Abuse 2004, vessels are strictly liable for violations, meaning intent or negligence does not need to be proven for penalties to apply. Coastal states have the authority to impose fines, detain the vessel, or refuse entry to ports if the ship is found in violation. Option A is incorrect because strict liability applies regardless of whether the discharge was accidental. Option C is incorrect because financial penalties and corrective measures apply, not just blacklisting. Option D is incorrect because under UNCLOS United Nations Convention on the Law of the Sea, coastal states have the right to enforce environmental laws in their waters. Question 10. During a comprehensive review of a process that needs improvement in a maritime insurance claim, a vessel owner sought coverage after ship ran aground in shallow waters. The insurance company denied the claim, arguing that the ship's master ignored navigational warnings, constituting willful misconduct. Under marine insurance law, what is the most likely resolution? A. The insurance company must pay the claim because grounding is covered peril. B. The claim should be denied if the insurer proves the ship owner's negligence contributed to the loss. C. The insurer must provide partial compensation considering contributory negligence. D. The ship owner can claim full compensation if the policy lacks an explicit exclusion for negligence. Answer: B. The claim should be denied if the insurer proves the ship owner's negligence contributed to the loss. Explanation: under the Marine Insurance Act 1906 UK and equivalent US laws, insurers can deny claims if the ship owner or master engaged in willful misconduct or gross negligence. Courts often require proof that the ship owner knowingly disregarded risks before denying coverage. The Star C 2001 Article 1. Option is incorrect because grounding may not be covered if negligence is involved. Option C is incorrect because contributory negligence does not typically apply in marine insurance. The claim is either valid or denied. Option D is incorrect because many policies contain seaworthiness clauses which void coverage for negligence. Question 11. In a case where multiple parties have different objectives in a ship sale transaction, a buyer sued the seller for misrepresenting the vessel's condition. The buyer alleged that the ship's hull had serious structural defects, but the seller claimed they had no prior knowledge of these issues. Under maritime contract law, what is the key legal principle that determines liability? A. The seller is liable if the buyer can prove fraud or intentional misrepresentation. B. The buyer assumes all risks once the vessel is sold, even if defects were hidden. C. The seller is automatically liable under implied warranties in maritime sales. D. The ship must be returned and the transaction voided, regardless of fault. Answer: A. The seller is liable if the buyer can prove fraud or intentional misrepresentation. Explanation: under the UN Convention on Contracts for the International Sale of Goods, CISC and Admiralty contract law, a seller is liable for fraudulent misrepresentation if they knowingly withheld material defects. E. Atlantic Baron, 1979, QB 705. However, proving intent is crucial. Option B is incorrect because buyer beware does not apply if fraud is involved. Option C is incorrect because implied warranties do not exist in every maritime sale unless explicitly stated. Option D is incorrect because voiding a sale is only an option if fraud or contractual breach is proven. Question 12. When scaling up operations that experience significant legal challenges, a ship management company decided to register a fleet under a flag of convenience to reduce costs. However, several crew members argued that they were being denied fair wages and legal protections. Under international maritime labor law, what is the most appropriate legal action for the crew? A. File a lawsuit under the flag state's labor laws. B. Seek protection under the Maritime Labor Convention (MLC) and request arbitration. C. Request intervention from the ship's owner in its home country. D. Accept the flag state's labor laws as they have jurisdiction. Answer B. Seek protection under the Maritime Labour Convention (MLC) and request arbitration. Explanation: the Maritime Labour Convention (MLC) 2006 establishes minimum wage, working conditions, and dispute resolution mechanisms for seafarers. Crew members can challenge unfair treatment via arbitration or report violations to port state authorities. Option A is incorrect because many flag states have weak labor laws. Option C is incorrect because the shipowner may not be directly responsible if they use a third-party management company. Option D is incorrect because MLC protections override flag state labor laws if the state is a signatory. Question 13. A vessel operator was sued for failing to maintain proper navigational safety protocols after a collision in busy waters. The defendant argued that the other vessel was equally at fault under the rules of comparative fault in Admiralty law. What is the likely legal outcome? A. The damages will be split proportionally based on each vessel's degree of fault. B. The vessel with the smaller gross tonnage is automatically less liable. C. The defendant is only liable if they were the primary cause of the collision. D. The case will be dismissed if both vessels contributed equally to the accident. Answer A. The damages will be split proportionally based on each vessel's degree of fault. Explanation: under the international regulations for preventing collisions at sea, Colregs and U.S. Admiralty Law, U.S. Supreme Court, United States v. Reliable Transfer Company 421 U.S. 397, 1975, liability is apportioned based on fault percentage rather than a strict rule favoring one party. Option B is incorrect because vessel tonnage does not determine liability. Option C is incorrect because even partial fault results in liability. Option D is incorrect because equal fault does not eliminate damages. Each party must pay their share. Question 14. During a major transformation where existing methods are being replaced with automated systems, a company implementing blockchain-based smart contracts for international shipping faces disputes over contract enforcement. Some stakeholders claim that smart contracts should follow traditional maritime contract laws, while others argue that they are legally distinct. How should this conflict be resolved? A smart contract should be treated as fully autonomous, eliminating the need for traditional legal enforcement. B. Maritime contract laws apply only if the smart contract explicitly states jurisdictional preference. C. Courts must analyze smart contracts under both contract and maritime law to determine enforceability. D. The dispute should be resolved exclusively through blockchain arbitration mechanisms. Answer: C. Courts must analyze smart contracts under both contract and maritime law to determine enforceability. Explanation: blockchain-based smart contracts are still subject to traditional contract and maritime laws where applicable, while automation ensures execution. Disputes regarding interpretation, performance, and jurisdiction remain legal matters. Courts typically use contract law principles, such as offer acceptance, consideration, to assess validity. Option is incorrect because legal frameworks do not yet recognize smart contracts as completely autonomous agreements. Option B is incorrect because jurisdictional preferences are considered but do not override fundamental contract principles. Option D is incorrect because while blockchain arbitration exists, parties can still seek legal remedies outside the blockchain. Question 15. While analyzing the root causes of sequential problems in maritime cargo delays, an international shipping company identifies discrepancies in the legal treatment of force majeure clauses across jurisdictions. Some ports hold carriers liable for delays despite uncontrollable events. What legal principles determine liability in such cases? A. The force majeure clause is only valid if it is explicitly listed in the contract and recognized in that jurisdiction. B. Shipping companies are never liable for delays caused by natural disasters, regardless of contract terms. C. If a force majeure event is declared, all financial liability automatically transfers to cargo owners. D. Port authorities have absolute discretion in determining whether a delay is covered under force majeure. Answer A. The force majeure clause is only valid if it is explicitly listed in the contract and recognized in that jurisdiction. Explanation: the enforceability of force majeure clauses depends on contract wording and local legal interpretations. Some jurisdictions require specific language defining qualifying events. Courts also consider whether reasonable steps were taken to mitigate the impact before exempting liability. Option B is incorrect because not all natural disasters qualify under force majeure if they were foreseeable. Option C is incorrect because liability allocation depends on the terms of the bill of lading and legal jurisdiction. Option D is incorrect because port authorities may regulate delays but do not determine contract liability. Question 16. In a situation where formal requirements conflict with practical implementation, a shipyard faces challenges in meeting both environmental regulations and project deadlines. Engineers propose using temporary compliance measures to avoid penalties while continuing work. What legal and ethical concerns arise from this approach? A. Temporary compliance measures are acceptable if they are later corrected before final inspection. B. The company may face penalties for non-compliance even if corrective actions are planned. C. Project deadlines take priority over strict regulatory compliance. D. Ethical concerns are minimal as long as no direct harm occurs. Answer. B. The company may face penalties for non-compliance even if corrective actions are planned. Explanation. Regulatory compliance in environmental law and maritime construction is strictly enforced. Temporary compliance measures do not excuse legal violations, and companies may face fines even if corrective actions are planned. Ethical concerns include transparency, corporate responsibility, and environmental impact. Option is incorrect because violations, even if later corrected, can still result in legal action. Option C is incorrect because legal compliance cannot be ignored in favor of deadlines. Option D is incorrect because ethical concerns extend beyond immediate harm to include long-term environmental responsibility. Question 17. During an emergency response where multiple areas are impacted, a multinational corporation struggles to coordinate risk management strategies across different regulatory frameworks. What is the best legal approach to ensure compliance? A. Adopt a single standard that applies across all jurisdictions, regardless of local laws. B. Establish compliance teams that specialize in each country's regulations. C. Follow the most lenient regulatory standard to reduce operational costs. D. Ignore conflicting regulations and prioritize operational continuity. Answer. B. Establish compliance teams that specialize in each country's regulations. Explanation. International businesses must customize compliance strategies to match different legal frameworks. Establishing specialized teams ensures adherence to local laws, reduces liability, and improves crisis response efficiency. Option is incorrect because universal standard may not satisfy all jurisdictional requirements. Option C is incorrect because choosing the most lenient regulations increases legal risks. Option D is incorrect because non-compliance can lead to fines, operational restrictions, and reputational damage. Question 18. When scaling up operations that experience significant legal challenges, a company expands its shipping fleet into new territorial waters. Some countries impose stricter vessel inspection laws, creating conflicts between corporate policies and local regulations. What is the most legally sound approach? They challenge local regulations in international courts to maintain operational consistency. B. Modify corporate policies to align with the strictest applicable regulations. C. Follow only international maritime laws and disregard stricter local requirements. D. Seek diplomatic exemptions to bypass regulatory barriers. Answer. B. Modify corporate policies to align with the strictest applicable regulations. Explanation. Local port state control laws can impose stricter requirements than international maritime conventions. Companies must adjust policies to meet the highest applicable standards to avoid legal issues and ensure compliance. Option is incorrect because challenging laws in court is time-consuming and often unsuccessful. Option C is incorrect because local regulations take precedence over international laws in territorial waters. Option D is incorrect because diplomatic exemptions are rarely granted for private corporations. Question 19. During a comprehensive review of a process that needs improvement, an aviation manufacturer examines liability exposure in international product recalls. If a defective aircraft component is traced back to a supplier who bears primary legal responsibility. A. The manufacturer is strictly liable for all product defects, regardless of the supplier's fault. B. The supplier is liable only if they knowingly provided defective parts. C. Both the manufacturer and supplier share liability based on the jurisdiction's product liability laws. D. The customer assumes all liability once the aircraft is sold. Answer. C. Both the manufacturer and supplier share liability based on the jurisdiction's product liability laws. Explanation. Under international product liability laws, GE Product Liability Directive US. Restatement of torts. Both manufacturers and suppliers may share liability depending on the specific defect in contractual agreements. Courts consider manufacturers' due diligence in quality control. Suppliers' knowledge of the defect option is incorrect because some jurisdictions allow manufacturers to shift liability to negligent suppliers. Option B is incorrect because suppliers may be liable even without intentional misconduct. Option D is incorrect because liability does not automatically transfer to customers. Question 20. When implementing new protocols in a shared environment, a multinational corporation is rolling out a unified security policy across all its regional offices. Some locations have pre-existing security measures that conflict with the new protocol. How should the company proceed to ensure a smooth transition while maintaining security compliance? A. Enforce the new policy immediately, overriding all existing protocols. B. Conduct a gap analysis to assess conflicts and integrate necessary adjustments. C. Allow each region to continue using its own protocols for flexibility. D. Implement the new policy only in locations without existing security measures. Answer B. Conduct a gap analysis to assess conflicts and integrate necessary adjustments. Explanation. A gap analysis helps identify inconsistencies between the new security policy and existing measures. It allows organizations to adapt policies where necessary while maintaining compliance. Option is incorrect because immediately overriding all existing protocols without evaluation can lead to security loopholes and operational resistance. Option C is incorrect because different security protocols can cause vulnerabilities in communication and access control across offices. Option D is incorrect because leaving some regions without updates creates inconsistent security levels and compliance risks. Question 21. While examining inconsistencies across various units, a healthcare organization notices that patient data handling practices differ among its hospitals, causing discrepancies in compliance with HIPAA regulations. What is the most effective way to standardize practices while ensuring regulatory compliance? A. Require all hospitals to follow the strictest data handling policy from any location. B. Develop a unified standard while allowing flexibility based on local needs. C. Assign each hospital the responsibility of creating its own compliance procedures. D. Focus only on training staff rather than changing policies. Answer B. Develop a unified standard while allowing flexibility based on local needs. Explanation. A centralized but adaptable policy allows standardization while accommodating operational differences. This approach ensures HIPAA compliance across all locations without creating unnecessary disruptions. Option is incorrect because some policies may not be applicable in all hospital settings. Option C is incorrect because leaving compliance entirely to individual hospitals can result in inconsistent interpretations of regulations. Option D is incorrect because training alone cannot fix procedural inconsistencies in data handling. Question 22. During an emergency response where multiple areas are impacted and its services provider experiences a cybersecurity breach affecting various client databases, the company must quickly mitigate damage while ensuring minimal downtime for customers. What is the most effective response? A. Immediately shut down all affected systems until a full investigation is completed. B. Isolate compromised systems, notify affected clients, and deploy incident response measures. C. Continue operating as usual and address the issue quietly to prevent public panic. D. Wait until the source of the breach is identified before taking any action. Answer B. Isolate compromised systems, notify affected clients, and deploy incident response measures. Explanation. Cybersecurity best practices require a measured response that balances security, transparency, and business continuity. Isolating affected systems prevents further damage, while notifying clients and deploying incident response teams ensure quick remediation. Option is incorrect because shutting down all systems disrupts operations unnecessarily. Option C is incorrect because failing to notify clients can lead to legal and reputational consequences. Option D is incorrect because waiting too long increases the risk of further breaches. Question 23. In a situation where resource allocation becomes a challenge, a company expanding into international markets faces difficulties in evenly distributing budget and personnel across regions with varying demands. What strategy should leadership use to optimize resource management? A. Allocate resources equally across all markets regardless of individual needs. B. Prioritize high-growth regions while ensuring critical functions in low-growth areas. C. Focus on the most profitable regions and reduce investment elsewhere. D. Distribute resources based on historical performance without reassessing current needs. Answer: B. Prioritize high-growth regions while ensuring critical functions in low-growth areas. Explanation: strategic resource allocation requires balancing growth opportunities and essential operations. Prioritizing high-growth markets while maintaining core functions ensures long-term sustainability. Option is incorrect because uniform distribution ignores regional demand variations. Option C is incorrect because neglecting low-performing regions may result in missed opportunities for growth. Option D is incorrect because past performance does not always reflect future needs. Answer: B. Provide training programs and involve employees in the transition process. Explanation: resistance to change is common in workplace transformations. Providing training programs and involving employees in the process helps build trust and ensures a smoother adoption of automation. Option F is incorrect because excluding employees increases resistance. Option C is incorrect because penalizing employees fosters negativity and reduces morale. Option D is incorrect because delaying changes hinders innovation and progress. Question 25. When developing a solution that must address opposing needs, a software company designs a new product that must balance user-friendly design with advanced security features. What is the best way to ensure both priorities are met? A. Focus entirely on security, even if usability suffers. B. Develop user-friendly features first and add security later. C. Involve both usability experts and security professionals throughout development. D. Allow users to disable security features for a better experience. Answer: C. Involve both usability experts and security professionals throughout development. Explanation: balancing usability and security requires collaboration between specialists in both fields. Involving experts throughout development ensures neither aspect is compromised. Option is incorrect because an overly strict security focus can make the product difficult to use. Option B is incorrect because security should be integral from the beginning, not an afterthought. Option D is incorrect because allowing users to disable security introduces risks. Question 26. In a multi-location scenario where consistency requirements must be met, a retail chain seeks to standardize customer service practices across all stores while accommodating local cultural differences. What is the best approach? A. Implement strict company-wide policies without local adaptations. B. Develop a core standard with room for localized adjustments. C. Allow each store to establish independent service policies. D. Rotate staff between locations to enforce uniformity. Answer: B. Develop a core standard with room for localized adjustments. Explanation: a flexible framework allows brand consistency while respecting local cultural variations. Option is incorrect because strict uniformity may not suit different customer expectations. Option C is incorrect because lack of standardization can lead to inconsistent experiences. Option D is incorrect because rotating staff does not address policy standardization. Question 27. During the introduction of new methods where coordination is essential, a financial institution implements AI-driven risk analysis. However, departments struggle to adapt due to knowledge gaps. How should leadership facilitate adoption? A. Require all employees to learn AI independently. B. Offer targeted training and cross-functional collaboration. C. Restrict AI use to a specialized team only. D. Gradually phase out existing methods without additional training. Answer: B. Offer targeted training and cross-functional collaboration. Explanation: targeted training and collaboration help employees integrate new AI-driven methods effectively. Option is incorrect because self-learning without guidance can lead to inconsistent results. Option C is incorrect because restricting AI use limits institution-wide benefits. Option D is incorrect because eliminating old methods without training disrupts operations. Question 20. While analyzing the root causes of sequential problems in a logistics network, a global shipping company experiences repeated delivery delays across multiple regions. Initial investigations suggest issues with both supply chain bottlenecks and unpredictable demand surges. What is the best approach to resolve these challenges? A. Focus solely on increasing warehouse stock to meet demand surges. B. Implement a predictive analytics system to anticipate and adjust supply chain operations. C. Penalize regional suppliers for delays to encourage better performance. D. Reduce shipping frequency to avoid bottlenecks. Answer. B. Implement a predictive analytics system to anticipate and adjust supply chain operations. Explanation. Predictive analytics can identify patterns in demand and supply chain bottlenecks, allowing the company to proactively adjust logistics operations and reduce delays. Option is incorrect because excess inventory increases storage costs and does not address supply chain inefficiencies. Option C is incorrect because penalizing suppliers does not resolve underlying logistical issues. Option D is incorrect because reducing shipping frequency could worsen delays rather than solve them. Question 29. During a seamless transition where continuity must be maintained, a hospital is upgrading its patient record system while ensuring uninterrupted medical care. What is the most effective way to implement this change? A. Shut down the old system and switch to the new one immediately. B. Run both systems in parallel for a transition period before phasing out the old one. C. Migrate patient records department by department over several months. D. Transfer only active patient records and leave historical data in the old system. Answer. B. Run both systems in parallel for a transition period before phasing out the old one. Explanation. Running both systems in parallel ensures data accuracy, minimizes disruptions, and allows time for troubleshooting before fully retiring the old system. Option is incorrect because an immediate switch increases the risk of data loss and workflow interruptions. Option C is incorrect because department by department transitions create inconsistencies in patient record access. Option D is incorrect because excluding historical data can impact long-term patient care. Question 30. In a case where multiple parties have different objectives, a government agency is working with private companies to implement new environmental regulations. While the agency prioritizes sustainability, businesses are concerned about operational costs. What is the best way to find a balanced solution? A. Enforce strict regulations without business input. B. Offer incentives and phased implementation to ease compliance. C. Allow businesses to set their own environmental standards. D. Delay regulations until businesses voluntarily comply. Answer. B. Offer incentives and phased implementation to ease compliance. Explanation. A phased approach with incentives helps businesses gradually adapt to new regulations without severe financial strain while still ensuring environmental progress. Option is incorrect because strict enforcement without business input can lead to resistance and non-compliance. Option C is incorrect because allowing businesses to set their own standards leads to inconsistent results. Option D is incorrect because delaying regulations weakens environmental progress.